Welcome and thanks for joining me on Talk the Walk. I'm Sarah Wong. Last month, Singapore approved a controversial law to counter foreign interference. The government said the Foreign Interference Countermeasures Act is needed to stop foreign parties from meddling in local politics. Apart from the details of the law, its introduction highlighted the practice of situating political control in the legal system in Southeast Asia. Today, we're joined by Carol Yuen. She's a lawyer from Singapore and co-founder of the Community for Advocacy and Political Education. Carol, welcome to Talk the Walk. It's great to have you here.
Thanks, Sarah. Thanks for having me here.
You bet. Well, first of all, can you tell us that why is Singapore's new anti-interference law significant, and why should people living elsewhere, for example, us who are living in Hong Kong, pay attention to it?
So I think the new foreign interference law, which is called the Foreign Interference Countermeasures Act, is quite new and in the entire world. And there are other foreign interference laws in other countries such as United States and Australia. But the one in Singapore is quite different because it doesn't just rely on declarations, but rather it gives the Minister of Home Affairs the power to institute certain directions to stop communications in Singapore. So there are two parts to this act. One part is that there are provisions for the minister to be able to give directions in order to stop communications in Singapore, as well as there are provisions for offences about clandestine foreign interference. These are measures that are designed to counter foreign interference in the form of hostile information campaigns. And that's something that is becoming an increasing problem. So this law is quite new in trying to target that.
Okay.
The second part of the law is about political donations. So this is derived from a previous law called the Political Donations Act, but it does open up, it does increase the restrictions against certain politically significant entities, and they will be able to, they will have more restrictions in terms of how they can run the activities and who they can receive donations from.
Okay. You mentioned the law, this new anti-interference law in Singapore gave the Minister of Home Affairs new power to conduct or to launch measures to counter foreign interference. I was wondering, is that new? Like, is it normal, or is it customary for a minister in the Singaporean government, the Home Affairs Minister, to have that kind of power before the passage of this law?
So before the passage of this law, what is in existence in Singapore is the Prevention of Falsehoods Manipulation Act. And that is something that, Protection from Falsehoods Manipulation Act. So that is something that prevents fake news from arising in Singapore, but that requires the existence of a false statement of fact. However, in terms of the new anti-interference law, what the minister would be concerned with is whether the communications activity is against the public interest in Singapore. And the definition of public interest in this act is quite wide. So it includes activities that would undermine the confidence in the government, but it also includes activities that would be directed towards a political end in Singapore. So if the minister finds that it is necessary or expedient to stop such activities from happening, to prevent any interference that is directed to that political end in Singapore, then it can implement the direction. And when the Act talks about directed towards a political end, it refers to a lot of political activities, including discussions about proceedings in Parliament, discussions about matters of public controversy. So in that sense, it would cover a wide range of issues, and public interest would encompass a wide range of issues.
Okay, I see. Now, Carol, you're a lawyer, so I want to seek your opinion on this. Like, one of the objectives cited in this bill is to minimize, if not eradicate, quote, hostile information campaigns waged by foreign entities on social media and in a bid to influence local politics, local elections in Singapore. But a major social media platform, Facebook, have said that it hasn't detected any covert influence operations in Singapore. So I want to ask you about the legal foundation of the bill. Does that weaken the government's case for the new measures if there hasn't been any set operations?
Yeah, so I'm not personally aware of whether there are any such operations in Singapore, but based on what the Minister for Home Affairs and Law, Minister Shanmugam, cited at the reading of this law in Parliament, he did say that there have been studies, which he didn't disclose many details of, but he did say that they found that there have been such covert activities happening in Singapore. So this act is designed to counter that. And also one more prominent example is the case of the academic named Huang Jing, who was found to have cooperated with foreign intelligence agents, and he was sent back to his country by the Singapore government.
Right. Okay. Now let's look at the procedural part of the legislation. Now, the Singapore government tabled the bill in mid-September and passed it in early October. Now, for those who are not familiar with Singapore's parliamentary efficiency, is it a reasonable time frame to pass a major legislation like this anti-interference law?
It is quite a short time frame, and usually what happens in the passing of the laws is that there is a first reading in Parliament, usually 1 month before the second reading of the bill is done. So there will be a 1 month's notice before the bill is debated in Parliament, at least. Sometimes before a major bill, the government will institute a public consultation process and gather opinions from the public. In this case, for this bill, there wasn't such a public consultation process. So what the minister did say in Parliament, though, was that discussions had arisen over this bill in other contexts, for example, in the discussion of the fake news legislation. But of course, the discussions then were directed towards the fake news legislation, and there wasn't a specific discussion in relation to this bill. Although anti-interference law has been discussed in Singapore at different times.
Well, we'll touch on the issues of the anti-fake news law later in the interview, but you mentioned public consultation, and I was curious because the government, the ruling People's Actions Party, and also the opposition Workers' Party, they all support countering the so-called foreign interference in Singapore, although disagreements remain on the means to achieve that objective. But I want to ask about what do Singaporeans think about this? You know, and how has it won the hearts and minds of the Singaporean public? And are Singaporeans worried that their freedoms or civil liberties and privacy will be infringed after the law is passed?
I think in general, Singaporeans do agree that it's important to combat against hostile information campaigns. It's just that there is some discomfort with the wide-ranging wording of this bill. The minister has tried to explain that this is because it's meant to capture different situations, different hostile information campaigns. But of course, because the minister can issue directions in the public interest, and this catches situations which relate to the discussion of political issues. Naturally, people who are more concerned are those who are involved in civil society issues, especially non-governmental organizations who may work with foreign embassies or who may work with foreign organizations, foreign NGOs to receive funding and to receive support. So there is a lot of concern about how this legislation will be used, and it remains to be seen how it will be used, even though the intention and the objectives, as stated, are supposed to be directed towards hostile information campaigns, which understandably is a very good objective.
Now, it's been weeks after the law was passed in the parliament. I wonder what changes have there been in the Singaporean general public, general society, that the people experience as a direct result of the passage of the law? Have there been any differences to people's daily lives?
The law hasn't been invoked yet, and I think the discussion has been a bit lesser since the law has been passed, because the law is now law, and
Yeah.
so we will have to look at how the government uses it when an opportunity arises. But I don't think anything has changed as of now.
I see. Now, we talk about the government and the opposition party. Their unanimous position is they support measures to counter foreign interference. And there's been some disagreements voiced by the opposition against the first draft of the bill in September. For example, concerns over abuse of power in the implementation and the lack of oversight. Why is the need to address alleged foreign interference politically universal in Singapore, despite disagreements over the, like I said, the implementation or the means to achieve said objectives?
I think foreign interference has been a recognized problem around the globe. So I think that's why the opposition party also recognizes that it's an important issue to tackle. And there have been many examples raised. For example, the issue of Russia and Crimea, and also the issue of the Chinese government and the relations with an Australian senator. So I think in light of these developments around the world, it's difficult for the opposition party to say that this law shouldn't be in place, just that they are concerned with the fairness of this law and how it's implemented.
Okay, well, let's pick it up after the break. Talk the Walk will be back in a moment. Don't go away.